All right. Good evening. Monday Night Live, episode 6. We're going to be going over lawful notification letters. Let me get this set up on my phone here. Let you guys get connected. Come on, there it is. All right. Good evening. Turn my sound off. Share. Oh, well, let me share like that, huh? Hello, Valerie. Hello, Susan. Hi, Alan. Hi, Claire. Michael. How you doing, brother? Brenda. Tanya. Hi, Bill. Hi, Doug. I can't even share my own stuff. What's going on here? Oh, wait. Man, they sure make it difficult. All right, now my phone's freezing up. Okay, here we go. Maybe I need to. Really? Man, phone's doing weird stuff, man. I see it keeps having an issue with the video stream as well. Now let's see, did we get it shared on my own timeline? Anybody else having an issue out there yet? Is it blanking out on you? Yeah, no one said this was going to be easy. No, it's not. Hi, Kathy. Hi, Chad. All right, so it's not blanking out for you guys like it is over here on my computer. All right. There's Brenda Johnson. Hey, I started like right at 6:30, so no waiting on Kirk's Law Corner tonight. Slackers. Oh. Okay, so as long as it's all good out there for you guys, right? Make this happen. Hi, Rosa. Glad you could join us. You're one of them busybodies out there. Usually don't get to watch our, well, I guess that's usually Wednesdays, right? In fact, I'm going to turn that off. There we go. Yeah, I'm feeling a little better. I've been pumping the heck out of that vitamin C plus my multivitamin, but yeah. Lawful notification letters. That's what we're going to be going over tonight. Pull that sucker up. I can thank Mr. Tony Pellegrino for that, as he did up this lawful notification letter. I may pull up a short little video here and play that. Yeah, still fighting a little crud stuff, but you know, it's that time of year. Crap, here in Idaho, it's like snowing one day and rain the next, and it's still being cold, but it's trying to warm up over here. We just basically gotta notification. My mom's on the Garden City Irrigation Board, so she has insight on our water levels and our reserves and stuff. And they're going to be dumping some water because now we're up to like 130 or 135% of our snowpack that we normally have. And we have 2 separate dams, and they got to start letting water out. We're going to start that on Wednesday so that we don't end up flooding, which for the last couple of years we've been flooding because of the weather. But yeah, it's pretty crazy that we've basically had January weather in February. We got so much snow in February, which we don't usually get much snow in February. We usually get that in December and January. But this year we got it in February. We got lots of snow throughout the month. All right, where is... Here we go. Is this one? Holy crap. Yeah, Brenda, I was seeing that Tennessee's already flooding down there or over there. You're in Pennsylvania, right, Alan? Freaking 9 degrees. And one more. Let me see if I got this right. I should have. All right. Where's the other one? That's that one, and then there's this one. That might be the same. All right, here we go. All right, lawful notification letter. Let me start. Jeez. I'll start with the little video first so we can, right on, Alan. Hell is freezing over here and I'm kicking their asses in district court. Good. Good for you. It's amazing what happens when you ditch that attorney and you know, stand your own ground and stand on your property and declare them. Uh-oh. Oh, man.
Declaring your status in an affidavit of status. This is
Where in the heck is it? Thought I'd saved it. Okay, here it is.
writing.
Okay. we go. I'm going to watch a short 11-minute video this gentleman made on writing a lawful notification letter, and then I'll show you what I've got. This is already uploaded into Kirk's Law Corner group. It's already in the file section. It's been there for quite some time. So thank you, Tony Pellegrino, for years ago giving this to me. So this is how we address our public servants. And we'll make it big.
A lawful notification letter. This is our fourth video in our series on creator-endowed rights. Writing a lawful notification letter is one way where we, as one of the people, can lawfully communicate with those elected oath-taker public servants, congressmen and senators, and serve notice of notification of our status as one of the people. It further serves to inform and educate those elected oath-taker public servants that we know and comprehend our rights, and that our oath-taker public servants have no authority to legislate away one of our rights or attempt to diminish a right of the people. If you are viewing this video and were not aware of our previous educational videos in this series, foundational information can be obtained in our 3 previous videos. Number 1, above the line, below the line. Number 2, the right to defend your rights. And number 3, declaring your status in an affidavit of status. It is important to view and comprehend these 3 previous videos to fully understand the foundation for writing a lawful notification letter. Rule number 1. If you don't declare your status as a living, breathing, sentient man or woman with creator-endowed rights, you will surely be treated as a straw man, creation of the state, and subject to every whim of every bureaucrat who desires to rule over you. Rule number 2. If you know your rights were endowed upon you by your Creator, and you also know that your Creator is not the state or federal government, then you will be able to establish your superior position as the master over your public servants. If your Creator-endowed rights are as important to you as they are to me, then there's no way you would give them up for the benefits of being subject to your oath-taker public servants. Here is a general idea how you can lawfully put your oath-taker public servants on notice that you will hold them accountable for violating their oath affirmation to support the Constitution, should any action on their part be construed to deprive or diminish one of your rights. Here's the lawful notification letter template. Your name, your address, your city, state, zip code, the date of your letter, by certified mail to your congressman or woman, U.S. Congress 203 Cannon House Office Building, or whatever their address is, Washington, D.C. 20515. Reference, your oath affirmation requires you to protect my right to defend my rights. Mr., your congressman's name here. This letter is lawful notification to you that you are corresponding with one of the people of these United States of America. See attached affidavit. Note, this would be a copy of your notarized affidavit of status as presented in our video declaring your status in an affidavit of status. As one of the people, I was endowed by my Creator with certain unalienable rights, one of those rights being my right to defend my rights. It is important that you know and understand that my Creator-endowed rights are protected and guaranteed by the Constitution and the amendments specific to the Bill of Rights. You took an oath affirmation to support and defend the Constitution, encompassing the amendments thereto. The United States Supreme Court has ruled that, quote, the state cannot diminish rights of the people, end quote, Hurtado versus California, 110 U.S. 516. Quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them, end quote. Miranda versus Arizona, 384 U.S. 436 at 491. Consider this your formal notification that all my rights must remain inviolate at all times. At no time have I ever given you a delegation of authority to vote to deprive me of a right or to even diminish one of my rights. Not only do I forbid it, but the Constitution forbids what it does not specifically grant. To vote on any issue that would ultimately diminish one of my rights would be a crime against me, a violation of your oath affirmation to support the Constitution, and would be considered warring against the Constitution. No state legislator or executive or judicial officer can war against the Constitution without violating his solemn oath to support it, end quote. Cooper v. Aaron, 358 U.S. 1 at page 18, 1958. Observing the many congressmen and women and senators would lead one to conclude they simply do not have the basic understanding of how their oath is their solemn binding commitment to support and protect the people's creator-endowed rights. They just do not possess the authority to tamper with the people's creator-endowed rights, period. The oath actually forbids the oath-taker public servant from attempting to deprive or diminish a right of the people. At the very least, you should be made aware that violating this oath is felony perjury, insurrection, sedition, and treason against the people. I believe it is also important for you to know and understand that I do not have constitutional rights. If the state and federal constitutions and the respective bill, Declaration of Rights, were to vanish from the face of the earth tomorrow, I would still have all the rights I possess today. I can only be dispossessed of my rights if I am deprived of my ability to defend them. That deprivation alone would be actionable under federal statutes known as a Bivens action in 18 U.S.C. 241 and Section 242. It is not for any government or any oath-taker public servant to determine for me what is permissible for me to acquire and possess in order to defend my rights to life, liberty, and the pursuit of happiness. By this letter, notification is given that I will be monitoring, maintaining a record, and evaluating any and all communication and actions by all parties specific to this matter pursuant to my creator-endowed rights secured and guaranteed by the federal Constitution and amendments specific to the Bill of Rights. Any oath-taker public servants operating as, quote, the federal government, end quote, that would vote or otherwise attempt to diminish one of my rights, including the right to defend all my rights by the modes, methods, and technologically advanced tools of the day, will be determined to be a direct assault upon and infringement of my constitutionally guaranteed and secured creator-endowed rights. Should any infringement of my guaranteed and secured rights occur on your part or by any party with whom you claim any affiliation, I will scrutinize said infringements and any injury therefrom pursuant to federal statutes known as a Bivens action in 18 U.S.C. 241 and 242 at minimum, and I will proceed accordingly. Should there be anything in this formal notice that you lack understanding or that needs clarification, please respond within 21 days. All rights reserved. Your name here, American citizen. Attachments, affidavit of status, carbon copy file. From the daily actions taken by our congressmen and women, our senators, president, and those secretaries heading up all those federal bureaucracies and agencies, it is obvious they either possess an ignorance of the rights of the people or an ignorance of their limited delegation of authority. Yet perhaps they are not ignorant of those matters at all. If they are not ignorant of the rights of the people or their limited delegation of authority, then they are knowingly violating their oaths of office by opening their mouths. If they are ignorant of the rights of the people or their limited delegation of authority, they will not have that excuse any longer after you serve them by certified mail your lawful notification letter. Like a child that is first spoiled, then attempted to be disciplined by his parents, you can be sure your oath-taker public servants who have been unrestrained by their masters, the people, in the past, they will surely go kicking and screaming when their masters, the people, once again serve notice that their actions will be monitored and scrutinized under federal law, a Bivens action for federal actors, and Title 42 U.S.C. 1983 for state actors. If you were writing a letter similar to this to put your state representatives, senators, governor, or anyone else in a public servant position, you would replace the Bivens action with Title 42 U.S.C. Section 1983. This simple letter will serve several purposes. Number one, it will educate your public servants that you know your rights and your rights cannot be violated by them. And two, It will educate your public servants that their oath of office means they will protect all your rights all the time while operating in their official capacity. And 3, they will no longer have excusable neglect for having, quote, not known or realized, end quote, they were violating your rights. And 4, they will no longer have excusable neglect for not realizing they were violating their oath of office. The fact is, every elected oath-taker public servant is presumed to know the law. Do they? By their actions, most would agree that answer would be no. A lawful notification letter may be the most effective tool you have to lawfully communicate with your oath-taker public servants that you will not accept them violating your rights or violating their oath of office. Be respectful when you write your letters, even if you are upset with your oath-taker public servants for their past actions. This is your opportunity to make a difference. When the people stand up for their rights and hold their oath-taker public servants accountable for their actions, we can and will see a positive change in their attitude toward us. Viewing this video will only be a waste of time if you don't take the time to sit down and write some lawful notification letters. They are your servants. You can't complain about their work if you don't instruct them on what they are allowed by you to do for you.
All right. So there you have the basics of a lawful notification letter. Now I tried to go to their site that he has listed there, and there's basically absolutely nothing there. It's kind of like just a blank page, and it gives you links to all these other things, but nothing what they talk about here. So I don't know what happened. Maybe it's been changed over time or whatever. But so in Kirk's Law Corner, in the files section, in the group, the study group, and this is why we need to understand a study group is like going to the law library and studying. It's not for memes. It's not for posting videos. You know, try anybody. Well, I don't want to use this particular book because this actually does have pictures in it, but you know, most law books don't necessarily have pictures in it. You know, the Kirk's Law Corner group is specifically to study the law and share what you've studied. So in the file section is a lawful notification letter, and it looks like this looks like this right here. So here's the lawful notification letter that's in Kirk's Law Corner group in the files section. Okay, this letter is a lawful notification letter to you and whoever's name it is. Okay, this doesn't necessarily have to be to your representatives. This could be to the sheriff. This could be to your local police officer, your social worker, because everyone from Article 6, Clause 3, everyone from the legislative branch, executive branch, and judicial branch shall be bound by oath or affirmation, or you're impersonating a public official, which that's a big no-no. That in itself is an emoluments violation. So, right, Malika? I'm at a point where I just want to send them a photocopy of my middle finger. But then I remember I'm their teacher first, not their punishers, right? We're not supposed to use force and violence against them, right? We're in a civilized society here. We're supposed to communicate with one another, due process of law. So notification of legal, lawful responsibility is the first essential of due process of law. Imagine that. If silence is acquiescence under the law, silence can only be equated with fraud where there is a legal or moral duty to speak, or where an inquiry left unanswered would be misleading, whether intentionally or not. Responses that are immaterial or irrelevant to the subject matter, or that are general and non-substantive, will be treated merely as a provision of information and legally as non-responsive, with willful intent to defraud. Okay? In order to ensure unequivocal clarity, and to effect the removal of any and all, here we go, assumptions and presumptions. We don't like to assume anything, right? We all know what it means to assume something. Kind of makes a assume out of you and me. We don't want to be doing any assuming. We don't want to act on any presumptions. You are hereby put on notice that this notification is not directed to the legal fictional person, upper lowercase name, no, uppercase name, but to you in your individual capacity, in your private capacity as a non-fictional entity who was sworn an oath of office, and who, by virtue of that oath, has a mandate to serve the people that are of the public, right? The people's contracts being the ancient charters of freedom, part of the Declaration of Independence, the Virginia Declaration of Rights, and the Magna Carta. Those are charters of freedom, corporate charters, and statutes confirming the liberties of the subjects, biblical law, Treaty of Paris, 1783, the maxims of common law. We do a lot of those. Maxims of law are fundamental principles, right, of law. That's why they call it the rule of law, because it controls law in and of itself, because again, we're talking about principles. 2 + 2 = 4. Let me know when you think you can change what that plus sign dictates is the correct answer, because you cannot change that principle without completely destroying mathematics. I mean, can you imagine if we were to change what the plus sign actually meant and does? Just that one principle in mathematics, what would that do to mathematics? It would literally just destroy mathematics. Well, that's why we have the rule of law, so that you cannot destroy law. Constitution of the United States of America with the Bill of Rights, Constitution of the state of whatever state you're in, right? And every additional ordinance of man that inherently recognizes the supremacy of God, like our state constitution, state of Idaho, you know, it specifically says, the preamble, very first part of the Constitution for the state of Idaho, we, the people of the state of Idaho, grateful to Almighty God for our freedom to secure its blessings and promote our common welfare, do establish this Constitution. Clearly, we're establishing the Constitution to institute government to protect our rights that come from God. They don't come from man. Our rights come from God. That's the reason why our founders did it that way, is so that no man, family, or set of men could arbitrarily take them away. You cannot touch those. We can't give them away. They're not ours to give away. They come from God. That's what part of unalienable means. I know he said unalienable. Everybody else talks about unalienable. But the truth is, it's unalienable. You cannot place a lien upon these creator-endowed rights, right? You can't tax them. You can't take them away. You cannot deprive them. Now, without due process of law or due course of law, right? There's a process that's due to your fellow man to deprive them of these fundamental rights, right? In a civilized society, we have to follow that process that is due, because that right imposes a duty upon us to follow that. That's what's due to your fellow man. And then you have processes that are due to public servants. And if you're not following that process, you're trespassing the law. You're violating the law. That's the law of the land. You got to follow the law just like everybody else. No man is above the law. You have to follow due process of law. Be it therefore known by these presents that I, all right, let me back up here. We were still right here. Public servant constitutes an irrevocable and unconditional offer of intent by the respective and adoptive governments and their officers to act, right, perform specific duties under their contract of employment, their emolument, their scope and authority, or refrain from acting. That's right. You have to stay within that little box we, the people, gave you consent to be in and to operate, to act in. Okay? In a specified way towards private citizens and for other purposes. I may have to change some of this, but and is binding upon those who choose to be subject to it, as your oath of office has so bound you as a public servant of our government. Be it therefore known by these presents that I, all upper and lower case, that's the man part, not the straw man, not the all caps, but upper and lower, proper, a competent, natural born man, woman upon the land, do hereby and herein give formal notice of acceptance of the mandated oath of office of the above named public servant, right here, in their proper name. The said oath of office being your open and binding and irrevocable offer to which may accept my acceptance, does hereby ratify into a firm and binding private bilateral contract between us, by which you agree to uphold the supreme law of the land, also known as the Constitution of the United States of America, with the Bill of Rights, and to perform all of your duties as a public servant, and to uphold and protect my rights, by which I agree to receive the said and the implied protections and provisions of that law, and of my rights, both as and of the services of your office, right? Emolument, a lawful payment for services rendered. Those services rendered must be lawful, right? That's just the one part of an emolument, the payment part. As the valuable consideration passing between us that consummates the acceptance of the contract as it was offered, right? It was offered through the social compact. And that contract of employment is found in Article 6, Clause 3. So you have the social compact. That's between the people and those who wish to serve the people in government. And they're limited in their scope and authority by the subject matter that was delegated per the Constitution. And the legislature and Congress have not the authority to alter the fundamental law or the Constitution. I mean, it's completely illogical to think that we, the people, lay down, ordain, and establish the law and the Constitution, and then the Constitution creates these emoluments, these positions in government, and then for them employees to dictate to us what their job description is and what duties they're going to perform. No. And this is a discussion argument that I just was having before the show here tonight, is the fact that we are not a representative democracy. We're not a representative government. We are self-governed. We have a constitutional republic as a social compact, and the contract of employment, again, Article 6, Clause 3. I don't care what branch of government you're in. You shall be bound by oath or affirmation to support this Constitution. That's just the way it is. That's the way our founders set it up, right? And these are servants. Servants do not dictate to us what our rights are, how we exercise them, where we exercise them, right? They can't claim standing in law to claim a right to a cause of action against us when they're not the injured party. That's not how it works. That jurisdiction has no standing in law. It would be foreign to our form of government and repugnant to the law. So, the said oath of office being your open and binding irrevocable offer, to which my acceptance does hereby ratify into the firm and binding bilateral contract. So that's kind of what this does, is it reaffirms that, hey, you do have your oath of office on file, right? Signed, sworn, subscribed, oath or affirmation. Because without that, how do you go to work at McDonald's without signing the contract of employment? I'm pretty sure that I can't just walk into McDonald's and go back there and start making some French fries and hamburgers. I'm pretty sure that I would get thrown out of there because there's no contract of employment. I don't have any standing in the law of the contract. The terms and conditions of the contract is the law that gives me the standing to be there to make French fries and hamburgers. I'd get thrown out of there. So same principle applies here. We got these bad actors or pretending, impersonating public officials, like CPS workers, social workers. I know they're not bound by oath or affirmation. I've asked them, you do have an oath or affirmation, right? Oh, no, we don't have to have one. Article 6, Clause 3 says that everyone from the legislative branch, executive branch, and judicial branch shall be bound by oath or affirmation to support this Constitution. Again, you do have your oath or affirmation on file, right? You did take one, right? Oh, well, we're not. Well, wait a minute. Yeah, go ahead. Say that again, that you're not required to take one. Because the social compact says you do. That means you're impersonating a public official. That's fraud. That's treason. All right, so be it therefore known by these presents, you're presenting this, that I, your, whatever, I don't know why, oh yeah, your, forget it, a competent, natural born man, woman upon the land, do hereby and hereon give formal notice of acceptance of the mandated oath of office of the above named public servant. Okay. The said oath of office being your open and binding irrevocable offer, to which my acceptance does hereby ratify, again, back into the contract, which you agree to uphold the supreme law of the land, also known the Constitution of the United States of America, right, and the Bill of Rights. Anybody who says, well, the Bill of Rights doesn't apply to the states, that would be SMU. Again, Bills of Rights, and especially those that are merely declaratory of the common law, this would be rights that are merely declaratory of the common law. These rights are common to all. This is a declaration of rights, the law. That's how we lay down the law, rights as law. And to perform all your duties as a public servant and to uphold and protect all of my rights, because that's what we instituted government for, by which I agree to receive the said and the implied protections and provisions of that law and of my rights, both as and of the services of your office, as the valuable consideration passed between us and consummates the acceptance of the contract as it was offered. This, my notice of acceptance of your oath of office, is made in good faith and explicitly without recourse. The contract now between us, now irrevocable consummated, pertains to your having knowledge of the law and having the power to stop a wrong, and thus the duty to stop a wrong from being done, particularly where such a wrong results in or causes any deprivations to my religious freedoms and or my civil rights, so natural rights and civil rights, and or my natural rights and liberties. Okay, well, he wrote it a little bit different there. The deprivation of which in whole or in part shall be deemed a breach of contract, a violation of substantive due process, a breach of public trust, a breach of fiduciary duty, all or any of which shall be held liable for without recourse and without further notice. Now, this is where you have to get it notarized, right? And another thing I would want to add in here is under jurat. So those little tidbits here we might need to clean up, and I really like to get with Tony again and go back over these lawful notification letters, and because I do have another one here that's pretty much the same. This one. This one has a little, wait a minute. No. Did I share the wrong one? That's that one. I thought it said requires your response. Oh, yeah, okay, it's right here. Okay. This notification requires your written response specific to the subject matter. So if you want to ask any specific questions, you know, in the form, basically, kind of like a statement of facts, like, are you, or did you do this on such and such date? Well, like, did you trespass upon my property and seize my children without a warrant on such and such date? Well, yeah, I did that without a warrant. And again, this is also building your court of record, because this is a lawful document. Okay. And with it being notarized, having it notarized, because a notary is an officer of the state. So that makes that a lawful, right? A lawful document, not a legal document, a lawful document. That's why it's called a lawful notification letter. Nope, I haven't, Melissa. I haven't tried to look up any guardian ad litem's DUNS number. You would have to probably, if you're going to look up guardian ad litem's, you'd have to look up the corporation, their acting number, whatever they're acting under. See, there's another thing. I don't know if guardian ad litem's is lawful. Where in the Constitution does it say that the legislature of the state of whatever can create those emoluments and then force you into them? You know, they try to say that the guardian ad litem is for your child, the attorney that's acting in the best interest of the child. Well, wait a minute. I thought that falls under the parental right, as the parents have the high duty, right, to defend their children. They have all decision-making power. So how can you take that away from a parent without due process of law and delegate that power to somebody else and then pay them to do that? Sounds a little bit unlawful to me. Right? Right, Chad? That's it. They would be under some sort of an agency. Yep. I can define what the best interest is. None of your damn business. How do you like that, Chris? So, yeah, best interest of the child is the duty of the parents to act in the best interest of the child. I mean, let's see. We're all creations of God. And the parents are supposed to have the care, custody, that's support, the care, custody, and nurturing of the child, education, medical decisions. I mean, everything. Nowhere in law does it say that somebody else has authority over your children other than the parents. And in fact, you want to get right down to the actual law of nature and nature's God under family. The father actually has all the power over his children. Nothing happens without the father's consent. I know that might rub some people the wrong way, but I didn't write it. I didn't write the Bible. I didn't write the law of nature. That's just the way it is. It froze. Well, still working over here for me, looks like. Hopefully it's still working out there for you. Well, you know, sometimes when we get into this nitty-gritty stuff, they really don't like us sharing too much. Oh, let's see. Let me see, do I have... Okay, so I have one here that I'm working on. I'll show you what I've been working on here. So I'm adding to this lawful notification letter this is Wisconsin code. Part of what's in their policy, right? This is their statutes, their policy. So taking a child into custody, a child may be taken into custody under any of the following: a warrant, a capias issued by a judge under blah, 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 an order of a judge made upon showing satisfactory to the judge that the welfare of the child demands the child be immediately removed from his or her present custody. A, B, and C. I just don't see anywhere where it says you can take them without following due process of law. Now, I showed you in my Idaho code, same thing. They're not allowed to do that. And then they got CM, an order of the judge, if made upon a showing satisfactory to the judge, the child is an expected mother, right? Habitual lack of self-control in the use of alcohol beverages, controlled substances, or controlled substance analogs exhibited to a severe degree. Like, you know, if the mom's passing out on the couch from drugs, alcohol, for hours. Okay, that's a severe degree. Now, I actually have American jurisprudence on some of this stuff. Even a drug user or an alcoholic, you can't take the kids because why? That's not deprivation of food, clothing, or shelter. That's not physical or sexual abuse to the child. That's the strict scrutiny standard that must be proven. So again, you know, law, we're here. Circumstances in which a law enforcement officer believes on reasonable grounds that any of the following conditions exist: a capias or a warrant for the child's apprehension has been issued in this state, or that the child is a fugitive from justice. A capias or a warrant for the child's apprehension has been issued in another state. The child has run away from his or her parents, guardian, or legal or physical custodian. But when that's the case, when the child is a runaway, they have to immediately call the parents, right? Child is suffering from illness or injury or is in immediate danger from his or her surroundings, and removal from those surroundings is necessary, as in life or death situation. The child has violated the conditions of an order under blah, blah, blah. So this is what I'm putting in for lawful notification letter to the sheriff. This is going to be going over to the sheriff's department. Say, hey, you want to follow your own statutes? Here's what social workers did, and here's what they didn't do. And they're not even following their own statutes. So I've done a little bit of work on this, putting this together. The two of us actually rummaged through the Wisconsin code. And I've slowly just been copying and pasting this stuff in to this document. So how about this one? Peace, maintenance, powers and duties of peace officers. Peace officers. Sheriffs and their undersheriffs and deputies shall be and preserve the peace in their respective counties and quiet and suppress all affrays, routs, riots, unlawful assemblies, and insurrections. I don't see anything in there about, I don't know, exercising your right to liberty or anything like that. You know, we've gone over that in the treaties on arrest and false imprisonment. What are arrestable offenses and what are not? And a peace officer, anything that the peace officer would try to make an arrest for, it has to happen directly in front of him. He has to have firsthand knowledge. And when we're talking about disturbing the peace, you actually have to be arguing and fighting with another person, another man, right? And the officer has to come up and see that. If the peace officer doesn't see the actual physical actions taking place, you can't make an arrest because there's no disturbing the peace happening in front of you. So county law enforcement agencies may request the assistance of law. Wait a minute. County law enforcement agencies may request the assistance of law enforcement personnel. County law enforcement agencies may request the assistance of law enforcement personnel or may assist other law enforcement agency as provided in. It just doesn't make sense. If you already have law enforcement there, who's assisting? That's kind of an oxymoron, really. So yeah, you know, anything you want to put in the lawful notification letter, drop that stuff in there, right? It's the main thing we were talking about in the video there, going to like public servants, our representatives in government, lawmakers, right? So let's say we have a state legislature and they're making a statute that has something to do with the Second Amendment, your right to keep and bear arms. You could do a lawful notification letter in there and advise them that I didn't give you any authority over my right to keep and bear arms. You better stop doing what you're doing. Right? That's what I think we really need to be doing. Lawful notification letters. Now, back when Tony was telling me about this stuff, I was like, yeah, it seems like a good idea. And, you know, he stands by him pretty good. And now that I'm coming to the realization that I think this is actually a really great tool, like what the gentleman in the video said there, that this is about education as well, right? So try to stay civil, right? Making sure that you're treating your fellow man with dignity and respect, being civilized. So you know, and come from the angle of education, right? I'm educating you on, hey, you can't do that because the law says you can't do that. You don't have any authority over that. But if you want to continue doing that, going down that road, I'm going to hold you accountable and I'm creating the record. Right? This is part of the court of record. You know, Chris puts in some of his the petitions that he does. He's like, I made several contacts with these people. That's the record. That's the court of record. He's created a court of record of communication with these people, and they just blew him off. Well, you know what? As the treaties on arrest and false imprisonment says, it will be at your own peril. Right? And my phrase is, okay, you want to deprive me of my rights, you will suffer at your own peril. Miss Hawkins out there, I didn't say that you would suffer, that I would make you suffer, which is what you try to construe it as. It would be at your own peril. Your own actions, right? And the law, right? Lex pundit mendicatum. It's like one of the only ones that I can really say in Spanish or in Latin. The law punishes falsehood. You make a false statement against me, I'm going to hold you accountable. That's where our mindset needs to get. We need to get into the mindset of, you trespass the law, I'm going to hold you accountable. How are you going to do that? You're going to follow due process of law. You're going to notice them, and this lawful notification letter is actually, technically speaking, the first part, right, of due process. Notice. Hey, you're trespassing the law over there. You better stop doing what you're doing. And then the next one is, you're being sued. You got 21 days to respond. Now, a lot of people don't understand that at any time that your rights have been trespassed and have been violated, that automatically creates a separate right to a cause of action, independent cause of action, right? But you kind of need to defend yourself, right? Give rebuttal, do an affidavit of truth. And if they continue on that kind of stuff, well, that's immediate right to a cause of action. You don't have to wait. You can start a whole nother independent action. Because that's what it says under Rule 60D, Delta. In fact, let's go into that, because this is something that can be done, right, at any time. We'll go into the Federal Rules of Civil Procedure, because these are synonymous, and at least in my state, it's almost word for word, directly right out of Rule 60. Exactly, we're almost word for word. Why? Because it's the Federal Rules of Procedure. All right, let's make that bigger. Come on, let me make it bigger. Fine. I'll make it bigger before I share. All right. Why can't I get to that? Well, I know I'm going to do that, does it? There we go. All right, now that I got it all blown up. Now this is going to get into vacating fraudulent orders, vacating any kind of documents, anything that's been done, right? All right, so this is Rule 60 of the Federal Rules of Civil Procedure. Relief from a judgment or order, okay? Corrections based on clerical mistakes, oversights, and omissions. So this is clerical errors and mistakes. The court may correct a clerical mistake or a mistake arising from the oversight or omission whenever one is found in a judgment order or other part of the record. What are we talking about? The court of record. The court may do so on motion on its own, with or without notice. So, hey, hey, we found this error. We're going to go ahead and fix that. They don't need your permission to fix an error, right? They catch their own error. You can do it. You can do the same thing as well, right? Supplement. But after an appeal has been docketed in the appellate court, and while it is pending, such a mistake may be corrected only with the appellate court's leave. So they would have to go to the appellate court. Can we take leave to correct our errors and mistakes? So they have to seek permission from the appellate court if it's already in the appellate court. So on motion and just terms, the court may relieve a party of its legal representative from a final judgment, order, or proceeding for the following reasons. mistake, inadvertent, surprise, or excusable neglect. Surprise! Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59. So let's say you discovered that this court didn't actually have jurisdiction. Uh-oh. That this process doesn't have any standing in law. Uh-oh. That would you consider that newly discovered evidence? I would consider it newly discovered evidence. Fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by an opposing party. Okay, and these are technically speaking, they're supposed to be timely done, right? The judgment is void. The judgment has been satisfied, released, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying it prospectively is no longer equitable, or any other reason that justifies relief. Timing and effect of the motion. Okay, motion under Rule 60B must be made within a reasonable time and for reasons 1, 2, and 3, not more than a year after the entry of judgment or order of the date of proceeding. There they go, putting them limitations. 1, 2, and 3. Well, let's look at 1, 2, and 3. Was it 1, 2, and 3? Yeah, 1, 2, and 3. So for 1, the mistakes. 2, newly discovered evidence. 3, for fraud. Okay. But what is this? This is Rule 60D. Other powers to grant relief. This rule does not limit a court's power to 1, entertain an independent action to relieve a party from a judgment, order, or proceeding. D, Rule 60D, as an independent action. Grant relief under 28 U.S.C. 1655 to a defendant who is not personally notified of the action. Somebody who's watching right now should pay attention to that particular part. Insufficiency of service, insufficiency of process. You were not properly notified, and by the mail is not proper service. Not when it comes to starting an action. You must use a process server or be personally served. You cannot serve through the mail. Not when it comes to initiating an action. Okay? Set aside a judgment for fraud on the court. That is Rule D, Rule 60D, Delta 3. Set aside a judgment for fraud on the court. These are what? Other powers to grant relief. This rule does not limit a court's power under an independent action at any time to set aside a judgment for fraud on the court. Oh, look at this. They're trying to abolish writs. Writs are part of the common law. You can't abolish the common law. You don't have that authority to abolish the fundamental law. Right? So I want to go back over that again. Number 1, entertain an independent action to relieve a party from a judgment, order, or proceeding. So you go through a proceeding and you're like, oh, hell no. I'm taking this as an independent action over here, and I'm starting a separate case as an independent action. Not in the same court, not in the same case that you're in. That's what independent action means. Right? a cause of action, an independent cause of action. So you need to fully comprehend what's actually being said here for fraud upon the court, right? Right there. Set aside a judgment for fraud upon the court. Anything, any kind of an order, it don't matter. Can't do that. You did that unlawfully, and I'm taking it as an independent action, and we'll go see about that over here. You pull that. You know, a lot of people talk about, well, they just ignore us and they just go, you know, I made the motion, but they denied it. Take it as an independent action. Under Rule 60D. There's all sorts of fancy notes in here. And see, this is why we need to comprehend, and I'll show you down here lower, how when they're talking about, oh, yeah, but there's only a year on statute of limitations on fraud. No, that's for clerical errors and mistakes. There are no statute of limitations on fraud. Right? Because, let's see. Excuse me. See all these here nice little case laws that's in here, right? There's one part in here. Subdivision B, when promulgated, the rules contained a number of provisions, including those found in Rule 60B, describing the practice by a motion to obtain relief from judgments. And these rules, coupled with the reservation in Rule 60B of the right to entertain a new action to relieve a party from a judgment, were generally supposed to cover the field. Since the rules have been enforced, decisions have been rendered that the use of bills of review, quorum nobis, or audita corella, that's an audit of the record, I think, to obtain relief from final judgments is still proper, and that various remedies of this kind still exist, although they are not mentioned in the rules, and the practice is not prescribed in the rules. It is obvious that the rules should be complete in this respect and define the practice with respect to any existing rights or remedies. Existing rights. You cannot alter the fundamental law. You cannot alter our rights either. Remedies to obtain relief from final judgments. For extended discussion of the old common law writs and equitable remedies, the interpretation of Rule 60 and proposals for change, see this, blah, 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 blah. But it talks about here, the reconstruction of Rule 60B has for one of its purposes a clarification of this situation. Two types of procedure to obtain relief from judgments are specified in the rules as it is proposed to amend them. Two types of relief here, guys. Independent action or as a motion. One procedure is by motion in the court and in the action in which the judgment was rendered. The other procedures is by a new or independent action to obtain relief from the judgment, which action may or may not be begun in the court which rendered the judgment. You can go right out into a civil court, start a completely new action, and say there's fraud going on over here, and that changes the judge, that changes prosecutor or whoever, right? Everybody that's involved in that over there, we drag them out over here, okay? Various rules, such as the one dealing with the motion for new trial and for amendment of judgments, Rule 59, one for amended filings, Rule 52, and one for judgment notwithstanding the verdict, Rule 50B, and including the provisions of Rule 60B as amended, prescribe the various types of cases in which the practice by motion is permitted. In each case, there is a limit upon the time within which resort to a motion is permitted. At this time limit, and this time limit may not be enlarged under Rule 6B. If the right to make a motion is lost by the expiration of time limits fixed in these rules, the only other procedural remedy is by a new or independent action to set aside a judgment upon those principles which heretofore been applied in such an action. Where the independent action is resorted to, the limitations of the time are those of laches or statutes of limitations. There are no statutes of limitations on fraud, guys. Don't let them lie to you. Just because they say so is not true. And the key word is, oh, well, I just recently discovered this fraud. There you go. The committee has endeavored to ascertain all the remedies and types of relief heretofore available by quorum nobis, bill of review, blah, 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 blah. It endeavored then to amend the rules to permit either by motion or by independent action the granting of various kinds of relief from judgments, which were permitted in the federal courts prior to the adoption of these rules. And the amendment concludes with the provision abolishing the use of bills of review and the other common law writs referred to and requiring the practice to be by motion or by independent action. You cannot alter the fundamental law. I don't care who you think you are. That's a capital offense to alter the fundamental law. The common law is the law that is common to all. You cannot alter that. You do not have the authority to do that. I can't do it, so you can't do it. See, like this here, or newly discovered evidence. Oh, I've recently discovered the fraud. Oh, such as lack of jurisdiction, insufficiency of service, insufficiency of process. I don't care what you want to call it, right? When you discover the fraud, that's the start date. If you want to play the game of, oh, well, the statute of limitations on fraud, it's a year or 3 years or whatever. Well, I just recently discovered this fraud. Prove that I didn't recently discover it. Okay. Fraud, whether intrinsic or extrinsic, misrepresentation or other misconduct of an adverse party or express grounds for relief by motion under amended subdivision. There is no sound reason for their exclusion. Imagine that. There is no sound reason for their exclusion. Not even a statute of limitation. The incorporation of fraud and the like within the scope of the rule also removes the confusion as to the proper procedure. It has been held that relief from a judgment obtained by extrinsic fraud could be secured by motion within a reasonable time, which might be after the time stated in the rule had run. There you go. Fisk versus Booter. There's a case for you. On the other hand, it has been suggested that in the view of the fact that the fraud was omitted from the original Rule 60B as a ground for relief, as an independent action was the only proper remedy. I'm trying to find where they said that they consolidated, and this is what they did. They consolidated fraud into Rule 60 because it used to be just for clerical errors and mistakes. And then they added fraud for stylistic reasons. They put fraud in here, and that comes under that statute of limitations of 1 year under clerical errors and mistakes. And they're trying to pull the wool over your eyes on fraud and not clerical errors and mistakes. And they're trying to tie the two together. Right? The amendment settles this problem by making fraud an express ground for relief by motion. And under the saving clause, fraud may be urged as a basis for relief by independent action, insofar as established doctrine permits. See Moore versus Rogers. Federal relief from civil judgments. You know, this is on law.cornell.edu under Federal Rules of Civil Procedure. So all of this is usable, right? But they keep referring to 60B. They don't ever really cite D here, right? Right? Notes of Advisory Committee on Rules from 1987. The amendment is technical. No substantive change is intended. The language of Rule 60 has been amended as part of the general restyling of the civil rules to make them more easily understood and to make style and terminology consistent throughout the rules. These changes are intended to be stylistic only. BS. You actually consolidated D, fraud, in with B to actually, you're doing exactly what you say you're not doing. Exactly. Oh, well, what's supposed to be just, in general restyling, it's not supposed to change anything, right? Oh, but now fraud's only got a 1-year statute of limitation because we said so, because we added it stylistically in here with Rule 60. Fraud wasn't originally under Rule 60. So there you go on that one. This is everybody. That's fraud applies to everybody. Federal Rules of Civil Procedure. I mean, I can take you. Check this out. Take you right into my own Idaho Rules of Civil Procedure. Same, almost exactly verbatim, except it doesn't have all that fancy stuff at the bottom and all those court references and all that stuff. But I'll show you here. Rule 60D. Same rule in my state. Almost verbatim, word for word, exactly what it says in the federal rules. All right, here's my state civil rules of procedure, Rule 60, relief from a judgment or order, corrections based on clerical mistakes, oversights, and omissions, word for word. The court may correct clerical mistake or mistake arising from oversight or mistake. Exactly same words. Exact same words. Word for word. Come on. There we go. All right. This court may correct a clerical mistake or mistake arising from oversight or omission when one is found in a judgment order, blah, blah, blah. Arising from oversight or omission whenever one is found in a judgment order. See, it's exactly the same. Mistake, inadvertent surprise, or excusable neglect. Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59. Fraud. But then we get down here. D, other powers to grant relief. Word for word, exactly what it says in Rule 60. But it doesn't have all this fancy stuff down here giving you the case citations for research. So go over here to law.cornell.edu and get it from there. And do your research from there and on what you want to dig into and what it is you're wanting to do. Right? They're giving you all sorts of goodies right here. Right? It's how you do research. You'll go in and go, oh, okay, well, let's establish doctrine here. Okay. So we'll go and we'll find that case. We'll go and find that case and you read that case. And when you're reading that case, you'll find other cases that are referenced in there, right? That's how you do research, and you kind of go down those rabbit holes until you find everything that you want. You put that in your memorandum of law and points of authority, and you cite them as the points of authority, right? That's how you kick the crap out of them. This is how it works. You're going to be sui juris. You're going to have to perform your administrative duties. That's just the way it is. Nobody else can do this for you. And I'm going to tell you right now, hiring an attorney ain't going to do you any good. They're going to go in and admit the jurisdiction, and then they're going to take leave so that whatever happens, happens to you. They're there to attorn you. You hire them, right? Because their first line of allegiance is to the court, then to the public, and never to the client. Until we can get that fixed, which Chris, myself, John, anybody else out there going after the bar, that's what we're working on. That's a bunch of BS. That's a breach of confidence, right? That would be an unlawful contract. That attorney can't enter into a contract with you to defend your rights because his first line of allegiance is to the court. So that amounts to an emoluments violation under fraud, because you're under the presumption and assumption, right? This would be where you would have the right reasonably to infer that you're hiring this attorney to defend your rights, when it's so far from the truth it's not even funny, right? This is what we call the confidence man, the confidence scheme, scam, and fraud. And it is fraud. Yeah. Yes, Brenda, that's what I was saying before. Is like when you research a case, I mean, let's take the Hardwick versus Rican case. You get into the Hardwick versus Rican case, and given the opinion, they go and say they cite other cases, right? That's doing research. So yep, fraud it is. So, that's some of the stuff that's already in Chris's documents. The confidence man, confidence scheme, confidence trickery. We need to start citing this stuff in our paperwork and shutting this crap down. Yeah, we can use their stuff. Sure we can. When you're talking about findings of facts and conclusions of law, you're just citing the law, right? Those are just merely declaratory of the law. So, sure, you can use a statement made by a judge in the Supreme Court. Doesn't matter who says it. It's the truth. Me personally, I like to just go straight to the law. It says, the law says that in all capital or criminal prosecutions, a man has a right to defend or demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty. There you go. I just cited the law, my right as the law. I don't need any case law for that, do I? I'm reading the law. And if you can't comprehend the law as it is written, well, I think you're kind of like incompetent to even sit where you're sitting. Did you go to grade school? Did you pass? Because English language was pretty much fundamentally, the basics, was taught in grade school. If you can't read and comprehend the English language by the time you finish grade school, you might be stuck in grade school. Right? Melissa, putting them in brackets. And this is a key point here that I forget to mention a few times, is you have to put this stuff in brackets because it doesn't actually technically belong to us. It's actually copyrighted, right? So when you're citing those like United States Code, you're gonna want to put it in brackets, the four corners law, four corners rule. What that does is it's like, I'm giving reference to this, but it's not actually a part of my document. It doesn't actually exist. It only exists in form here as a reference. It is actually, it's not part of the document. I'm just referring to that. And that's for whoever's reading the document to refer to. It's not actually part of the document. So that's what the brackets mean, the four corners rule. So anytime you do any kind of citing, put it in brackets. For those of you doing the common law thing. For Chris, even Chris still does it sometimes, but Chris is acting in a little bit different capacity than the rest of us do, right? Chris actually has a corporation. It's called E-Clause LLC, Limited Liability Corporation. And it is a 501c4, a for-profit corporation. It is not a not-for-profit or non-profit corporation. It is a for-profit corporation. So, yes, E-Clause is licensed to practice law, because you can't license the practice of law as a man, but you can license the business, right? The business of law. And I still halfway disagree with that myself. So, Hale versus Hinkle. Yep, that's one of it's Henkel. Yes, Henk L. And I have that one on speed dial over here. Hale versus Henkel. That is such a good case to read. And there you go again. Here, we'll just go ahead and bring Hale versus Henkel up. Because, where'd you go, Hale? Oh, Hale versus Henkel. There it is. This is a case from 1906. This was a corporation importing some wine or something. Yeah, no need to clarify that, Chris. You and I kind of just disagree on that. If you can't license the practice of law, you can't license the practice of law. And everyone is free to employ themselves, right? So how would you license? And in fact, this actually destroys that whole argument right here. Oop, we got to go to the case. So we get down, it's clear. The main part of it's down here. But we're talking about doing research and how it leads you to other cases. This is a prime example because this has the Boyd versus U.S. case, which is an exhaustive case of the Fourth Amendment. In fact, I'll just do a Control F, go right to Boyd. There we go. The construction of this amendment, this is the Fourth Amendment, right? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That's a shall not. Uh-oh. And what do we talk about in the like the third or fourth episode there, going over the treaties on arrest and false imprisonment, right? The legislature cannot alter due process of law. They can't alter the law of the land, cannot alter the fundamental law. Why? Because it shall not be violated. And no warrants shall issue but upon probable cause. Some man claiming a right to a cause of action, he has to establish his standing. And that has to be what? Supported by an oath or affirmation, an affidavit of truth signed under penalty of perjury to claim his standing in law, to claim his probable cause of action. And it must particularly describe the place to be searched or the persons or things to be seized. So the construction, right, the making of this amendment was exhaustively considered in the case of Boyd versus United States, 116 U.S. 616. Okay, which was an information in rem against her cases of plate glass, cases of plate glass alleged to have been imported in fraud of the Revenue Acts. We're trying to get him for tax evasion, right? On the trial, it became important to show the quantity and value of the glass contained in a number of cases previously imported. And the district judge, under Section 5 of the Act of June 22nd, 1874, directed a notice to be given to the claimants requiring them to produce the invoice of these cases under penalty that the allegations respecting their contents should be taken as confessed. We held that a compulsory production of a man's private papers to establish a criminal charge against him or to forfeit his property is within the scope of the Fourth Amendment to the Constitution in all cases in which a search and seizure would be. Imagine that. You cannot compel someone to produce private papers to establish a criminal charge because it violates the Fourth Amendment fundamentally. And that the order in question was unreasonable search and seizure within that amendment. You're screwed. You got burnt. The history of this provision of the Constitution and its connection with the former practice of general warrants or writs of assistance, was given at great length. That's your traffic tickets. That's that peace officer writing you a ticket for disturbing the peace. That's a writ of assistance. Those are unlawful in our form of government. Was given at great length, and the conclusion reached that the compulsory extortion of a man's own testimony or of his private papers to connect him with a crime of a forfeiture of his goods is illegal, right? Is compelling a man to be a witness against himself within the meaning of the Fifth Amendment to the Constitution, and is the equivalent of a search and seizure, and an unreasonable search and seizure within the meaning of the Fourth Amendment. Kick rocks, you're burnt. Subsequent cases treat the Fourth and Fifth Amendments as quite distinct, having different histories and performing separate functions. Thus, in the case of Interstate Commerce Commission versus Brimson, the constitutionality of the Interstate Commerce Act, so far as it authorized the circuit courts to use their processes in aid of the inquiries before the commission, was sustained. The court observation in the connection, observing in that connection. It was clearly competent for Congress, to that end, to invest the commission with authority to require the attendance and testimony of witnesses. Why? Because you're under the Interstate Commerce Act. You're acting in interstate and foreign commerce. Yes. Article 1, Section 8, Clause 3. That's the Commerce Clause. But then we get down here a little bit further. And Right here's where it gets good. So I'm going to go back up here so you understand what's really going on here. Having already held that by reason of the Immunity Act of 1903, the witnesses could not avail himself of the Fifth Amendment, it follows that he cannot set up that the amendment as against the production of the books and papers, this is talking about the corporation under the Commerce Clause, right? Since in respect to these, he would also be protected by the Immunity Act. We think it quite clear that the search and seizure clause of the Fourth Amendment was not intended to interfere with the power of courts to compel, through a subpoena ducis tecum, the production upon a trial in court of documentary evidence. It would be utterly impossible to carry on the administration of justice without this writ. The following authorities are conclusive upon this question. If, whenever, an officer or employee of a corporation, CPS, there's your corporation, Department of Health and Welfare, there's your corporation. The Sheriff's Department, your 80 County Sheriff's Department, that's a corporation, okay? Everything is a corporation. They incorporate themselves into the corporate charter. It's been that way for a long time. Go back and read the First Charter of Virginia, 1603, 1606, 1609 is where it really gets into it. The Second Charter of Virginia, the Corporate Charter of Virginia. So, if whenever an officer or employee of a corporation were summoned before a grand jury as a witness, he can refuse to produce the books and documents of such corporation upon the ground that they would incriminate the corporation itself. We're talking about the corporation. It would result in the failure of a large number of cases where the illegal combination was determinable only upon the examination of such papers. So that's right. Can't do that, can he? Conceding that the witness was an officer of the corporation under investigation and that he was entitled to assert the rights of the corporation with respect to the production of its books and papers, not his actions, just the books and papers, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation, right? And so this is the problem. The clear distinction is you haven't declared your status. You haven't put them on notice of your status, right? Notice of special appearance, objecting to the personal jurisdiction because that fictional all cap letters name is not me, the individual man. They're listing you on the paperwork as a corporation. And unless you object to that, that's a tacit agreement. That's a presumption and assumption. Laches occurs, you're screwed. But that would be fraud upon the court, right? And jurisdiction can be challenged at any time. So they're saying here that there is a clear distinction between an individual and an incorporation, and that the latter being the corporation, what we're talking about, between an individual and a corporation, and that the latter, the corporation, has no right to refuse to submit its books and papers for an examination at the suit of the state. And this is why you have to do a petition of remonstrance and instruct your representatives in the Senate to order an investigation to these corporations, right? Okay. And it's a suit at law. And who is the representative to do that? That would be the Attorney General, who appoints a special prosecutor to prosecute the corporation that has acted outside the corporate charter, the law, and deprived you of your fundamental rights, which the corporation can't do, because the corporation is bound by the corporate charter, the Bill of Rights, and the Constitution. So you can't do that. And I'm going to go tell on you And I'm going to instruct my representatives to criminally indict you and follow due process of law in accordance with the corporate charter, the social compact. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. You can't even license the business. I don't have to seek permission to exercise a right. His power to contract is unlimited. There shall be no law impairing the obligation of a contract. Private contracts are not subject to inspection by anybody except for the parties to the case, party to the contract. You have to be a party to the contract in order to claim a right to a cause of action under the terms and conditions of the contract. Why? Because he owes no duty to the state or to his neighbors, right? We're self-governed here. To divulge his business or to open his doors to an investigation, so far as it may tend to criminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Whoever's right you trespass upon is the only ones that can claim a right to a cause of action. Now, upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated. Come on, right there. Give it to me, right there. Incorporated. Oh, you know what? You guys can't see this. I'm sorry. There. Now, where did I go? Crap. Okay, there it is. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. That's right. Corporations incorporate themselves supposedly to be a benefit to the people, the public. And not only that, when they incorporate themselves, their income, their profit is the income. People don't make an income. We contract our labor and we're entitled to the entire fruits of our labor, right? It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law, those statutes, right? That's what you're doing. That's what the statutes are for the corporations and the agents of those corporations. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. Oh, really? There's a reserved right in the legislature? Would that be for the Senate to order an investigation? For impeachment? To remove this this corporation, right? It would be a strange anomaly to hold that a state, having chartered a corporation to make use of certain franchises, could not, in the exercise of its sovereignty, inquire how these franchises had been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose. I want to see the bylaws of your corporation. I want to see the rules that you have promulgated and make sure that you're not in violation of the corporate charter. The legislature allowed you to be created. We, the people, created the corporate charter to allow corporations to incorporate themselves into the corporate charter, the law of the land. And we instruct our representatives to investigate these corporations and to criminally indict the individuals who are acting in their individual capacity. Well, but my policy says, I don't give a rat's ass what your policy says. You're bound by the law of your creation that allows you to be created. And in fact, in the Idaho Code, it even specifically says corporations that incorporate themselves into the state are bound by the Constitution of the United States of America and the Constitution of the state. Imagine that. So why do you think that is, folks? Because that's how our form of government works, to protect the people from all things foreign. Corporations are foreign to the people. Those corporations cannot manufacture things, goods, that would be injurious to the people. And so we're supposed to go to the legislature to remove those privileges and immunities that were granted by the legislature, right? And licensed through the executive branch, the licensing bureau that handles licensing corporations, that business license, the one that we, the people, don't have to do in the private, through private contracts. If we're going to act in interstate or foreign commerce, then we're supposed to go get a license, permission, right? A franchise, like McDonald's. McDonald's is a franchise. You have the main corporation, it'll have its corporate headquarters, right? That's the corporate headquarters that deals with the interstate and foreign commerce, okay? Then the rest of them are franchises under the corporate McDonald's. So not only do they have to follow the corporate charter that allows McDonald's to be created, but the franchises also have to be under the bylaws of McDonald's, the headquarters, right? The actual corporation bylaws and the policy of McDonald's, those franchises have to follow that. So this is where McDonald's could put stricter rules on the franchises that go over and above the law of the land, which is kind of hard to beat. But hey, at no point in time can the bylaws or the policy of McDonald's have the force and effect of law. Not on the people it can't. And in fact, not even on their own members. Cannot have the force and effect of law. You don't have the power to make law. Corporations can't make law. The state of Idaho is a corporation incorporated into the United States of America, the supreme law of the land, the Constitution. That's the corporate charter for the nation. Well, yeah, they might state different policy there, but you know, that's their corporate policy. So, but this is a really good case to read. This takes you down many different avenues of research, but the main one, and I've used this one, and it's funny. Back in 2014, when I used this case, the only thing that the prosecutor brought up was, well, except for in Will Hale versus Henkel and blah, 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 blah. So this case is a powerful case. Even the prosecutors and the courts recognize this case. But another one, seriously, the Boyd case. Really, really, really need to use the Boyd case. That's a one to research, right? So that you can fully understand the Fourth Amendment. And clearly, somebody's already gone down that rabbit hole, and the Boyd case has never been overturned either. And in fact, I believe I have the Boyd case uploaded to Kirk's Law Corner group. In fact, let me go check. Pretty sure I have it. Pretty sure I uploaded it in there. And it might be a zip file with multiple cases, but let me double check here. Let's see. Let me show you this. Now I'm in Kirk's Law Corner, the closed group here. I'm in the files section. Okay. This is how I recommend you use this group. Come in here, you come to the files section, and you go, what do I want to study? Hey, look, there's the emoluments, how-to reports and brief. And that was uploaded September 25th, 2018. Here's the statutes, codes, rules, and regulations are not the law. Now, again, this is one I've not had the time to verify all that stuff in there. I already basically know that, common sense knowledge to me. So if you're going to use any of that, go verify it. Now, the Hardwick versus Vreeken case, that is the case itself. That's the case file right there. There it is. Here's the executive order on established. That's July 11th. Yeah, that establishes the consumer fraud, Joint Task Force on Consumer Fraud. Here's the executive order for amendments to the manual for courts martial. Let's see, March 13th, that's the one Chris worked off, 13781. That's the one that was Trump was asking the people, right? In help in an audit of the executive branch. So Chris took him seriously, and here we are 3 years later, almost 3 years to the day now. Well, no, wait, 2 years, pardon me. December 21st, that is the human trafficking one. December 8th, that is the proclamation reestablishing the rule of law. For those of you that haven't read that, here, let's just open that sucker right up. If you haven't read this sucker and you don't understand what I'm talking about, reestablish the rule of law. You know how we've been under that, oh, the federal government's a corporation and all that. Well, you can thank Donald J. Trump for doing this. Okay. Our great country was forged in the fires of a revolution to overthrow the rule of a tyrant by a free people. Who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence to the Constitution and through the Bill of Rights, our country and our people have always known the true God-given nature of liberty and the ability of law to safeguard it against the state. For 226 years, the final piece of this freedom-sustaining bulwark, the Bill of Rights. So if it's a final piece of the freedom-sustaining bulwark, then why doesn't it apply to the states? Because it does. It's a Bill of Rights. Has formed the bedrock of the constitutional protection of every American holds dear as their birthright. That's right, because these are natural rights. Naturally, we have the right to be free from governmental intrusion. On Bill of Rights days, we recognize the importance of the first 10 amendments to our Constitution to protecting, right? Protecting our liberty. Liberty is a natural fundamental right, right? These are creator endowed unalienable rights. That's what it says in the Declaration of Independence. Among these creator endowed rights is life, liberty, and the pursuit of happiness. That's just among them that are creator endowed rights. And freedom against the inevitable encroachment of government. Our founding fathers understood, boy, did they ever, the threat of expansive, omnipresent government. What would that? Emoluments of statutable plunder. That's in the Declaration of the Cause and Necessity of Taking Up Arms, July 6, 1775. Then we go to March, and they believe it's March, no, it would be the second Constitution of South Carolina, 1776 there. Was other unconstitutional, anal, oppressive statutes. I didn't write it, they did. From the beginning of our republic, notice that doesn't say democracy. Notice it doesn't say representative democracy. Notice it doesn't say representative government. We're self-governed. We are a constitutional republic by the people and for the people. Thank you. Therefore, they endeavor to enhance the Constitution with a Bill of Rights, a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. Now, you want to tell me again that Trump isn't for the people? That Trump isn't trying to put the power back into the people's hands like he said at his inauguration? I don't care if you like Trump or not. I'm talking about what he said and what he's actually done and put in writing. This is truth, facts, and evidence. This is the evidence to support that truth, which makes it a fact of law. So, on June 8, 1789, James Madison, because this was at the Constitutional Convention in 1789, as they're talking about the Bill of Rights, originally skeptical of the need for a Bill of Rights, right? Because the Declaration of Independence said our rights were self-evident. What the heck do we need a Bill of Rights for? At this particular point in time, our rights are supposed to be self-evident, naturally, fundamentally. But, you know, they insisted. Imagine if we didn't have a Bill of Rights today. Well, what would we be doing now, right? We're fighting just to keep those. Oh, well, those don't really apply to the states. Yes, they do. Introduced in the Congress several amendments, and to be honest, there was 157 original amendments submitted, and they whittled it down to 12, and then only ratified 10 out of the 12. So that's why he was talking about introducing several amendments to the Constitution that would eventually form the Bill of Rights. During the ensuing debates, Madison told the Congress that because all power is subject to abuse, preaching to the choir here, right? Everybody watching here right now, I'm pretty sure we're all aware that they're abusing the power that's been delegated. It was worth taking steps to ensure that such abuse may be guarded against in a more secure manner. So much for that. They just do whatever the heck they want to do, don't they? Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please, the right to speak our minds and consciences, the right to firearms to protect ourselves and our loved ones. There it is. In other words, shall not be infringed means shall not be infringed. Congress is not the authority. We're talking about a Bill of Rights here. There's no authority to alter the fundamental law. Get on them lawful notification letters. Send them in there to your state representatives. Send them into your state representatives in Congress, United States Congress, and let them know, hey, little friendly reminder here. President reestablished the rule of law, and that includes the right to keep firearms to protect ourselves from you guys. And the Second Amendment says, I have the right to keep and bear arms, and it shall not be infringed. That's an usurpation of power. You're subjecting us, you're using your power to subject us to tyranny. That's unlawful. Stop doing that. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans, right? Firearms to protect ourselves and loved ones. The right to be free from unwarranted government searches and seizures. Where's your warrant? The right to a jury of our fellow citizens when accused of legal wrongdoing. Others, like the right to object to housing troops in our homes during peacetime. What are we doing with these standing armies? Are we not housing those troops by paying taxes to pay their wages, that their wages pay for their homes? Are we not housing those troops? Who's paying for their homes? I believe your tax dollars are paying for their homes. Are often thought as relics of a bygone era. Regardless of their familiarity or applicability to our daily lives, however, each clause of the Bill of Rights addresses profound and real abuses the founders faced, and each crafted and locked into law to protect us and future generations from their repetition of tyrants trespassing the law and exercising powers that don't belong to them. Since its adoption, the reach of the Bill of Rights has spread far beyond America's shores. That's right. One of a kind here. America has led the way in freedom of liberty, life, liberty, and the pursuit of happiness. As George Washington rightfully said, liberty, when it begins to take root, is a plant of rapid growth. Who in the heck doesn't like liberty without governmental interference? I can't think of anybody. Anybody out there? For example, in the wake of the devastation of World War II, the spirit of the Bill of Rights inspired the United Nations General Assembly to adopt what? The Universal Declaration of Human Rights in 1948. Now, you can go read that all you want, but I'll tell you, our rights that have already been laid down in multiple bills of rights are way better than this Universal Declaration of Human Rights. By far, hands down, everything that's in history in our declarations and bills of rights are far better than that Universal Declaration of Human Rights. But that's for the world. That is a Universal Declaration of Human Rights. And then here's the key. The first 26, I believe, 27 amendments, 27 articles, whatever, don't actually apply to the United States unless you invoke them. But they don't tell you that. So, just like the Bill of Rights, and actually I think it was 1993 when America actually signed on to this Universal Declaration of Human Rights. And that's when they said, well, we'll go ahead and sign on to this, but the first 27 amendments or articles don't apply unless the people claim them. So we don't have to follow them unless you bring it up. So go ahead and go read that. You can use that. Just like the Bill of Rights, the Universal Declaration of Human Rights is grounded in the recognition that just governments must respect the fundamental liberty and dignity of their people, because they're the servants. They can't alter the fundamental law. Fundamentally, you can't do that. By enumerating core rights, fundamental rights, that should be immune from government encroachment. That's right. Law of Nations, the Law of Nations, Book 1, Chapter 3, Section 34, went over this before. The legislature, Congress, has not the authority to alter the fundamental law or the constitutions. They just don't have that authority. Not ever. Fundamentally. Both the Bill of Rights and the Universal Declaration of Human Rights have helped fuel remarkable prosperity and achievement around the world. So, again, our God-given fundamental rights are soon overcome, if not safeguarded, by the people. How do we do that, folks? We go tell on them in the legislature. All right. So, hopefully you all learned something tonight. Get your lawful notification letters going. Let's get them sent in to public servants, right? We need to instruct our representatives that they don't have the power, okay? They do not have the power to alter the fundamental law. They do not have the power to make legislation that would deprive us of our fundamental rights. That's not a power delegated. That would be capital offense for you to do that. That's treason. That would be giving aid to our enemy. That would be legislating for us in all cases whatsoever. You don't have that authority. It's a declared act of tyranny. Tyrants are our sworn enemy through Declaration of Independence. That's what we declared our independence from. Tyranny, tyrants. We declared them as our enemy. Let these facts be submitted to a candid world. That is our declared enemy. And that's why it's treason, because that is giving aid to a known enemy. Tyrants are a known enemy. That's treason. Punishable by death, by the way. All right, so if you enjoy these shows, please support me in my endeavors here to help educate the people, do what I'm doing here, getting with my representatives locally. Please make some donations here to help support me. This is what I'm doing full time. Studying, research, education, helping people with paperwork, answering phone calls, all that good stuff. So if you can afford $10 here, $17.76, Michael out there's establishing that. I love it. $17.76. Please make a donation. Help support me in my endeavors. Help pay the bills. Keep this stuff going. So that would be Kirk_Pendergrass@hotmail.com for PayPal. If you're going to use PayPal, you can send a check or postal money order check, anything like that, cashier's check, personal check, regular money orders, it doesn't matter. Private donation, personal donation to me, send that to the office at 6477 West Fairview Avenue, Suite C, Charlie, Boise, Idaho 83705. Address is right here on the web page here, Facebook page, Kirk's Law Corner, if you need to come back and get that. I do appreciate those that have made donations. It's been helping me get by, and buying that paper and the ink and paying for Zoom is $55 a month, pays my cell phone bill, puts gas in my truck. You know, I live pretty light, so I don't need a whole ton of money. I don't have a mortgage. I don't have a truck payment. So just the basics here, you know, food, clothing, shelter, that kind of good stuff. Well, not even the shelter. I'm okay here. Just the basic necessities, really. And I appreciate your support. And I know that those who have donated to me have appreciated the education I've provided. So for those of you that have sent the emails about getting into the private Zoom class on, I'm going to be doing I'm probably going to be doing it this weekend. So get your email sent to me at kirk.eclausllc@gmail.com if you want to get in to the private class. I'm going to help you do cover pages. Okay, the cover page of your petition of remonstrance. You're already supposed to be working on your statement of facts. Okay, so you guys get your statement of facts going and get that done. Get your statement of facts done. So you can file your own petition of remonstrance, right? We can only do so much. And that's the reason why I'm doing this in a bulk, because I don't have the time to take away and talk to each one of you individually when I can sit right here and teach you, and I can go into a private Zoom class and teach you some real good stuff in private. Some stuff that I don't really want to put out in a live feed or even in video here. So you'll understand when we go private, some of the things that maybe you've been in here before. We've talked about things in private that we don't put out here. There's a lot more knowledge up here than what I'm letting on out here. So get in there, send that email. You want to get into the private Zoom class. More than likely that is going to be coming this weekend. And as soon as I create that Zoom class, I will send out an email and I'll let you know, right? And the first thing I'll do is I'll send you out an email of when it's going to be. And then the second email will be for the Zoom. You'll get the Zoom invite right before we go into Zoom. So make sure that you pay attention to your email when it comes time to get into the class. There it is. Thank you, Chris. Appreciate it. So much love to you all. Chris and John and I will be back Wednesday night. And seems that Chris always has something interesting. And these days, Chris, John, or I, all three of us, we all got something interesting to share. So I look forward to working with these gentlemen. They're brilliant men. I love these men with my whole heart. These are great men, which is why I chose to work with them, to build what we have built here. I may have put this together and pulled it together, but we're a team, and we make one heck of a team. So at least that's what I think. I love them, guys. I love you folks out there. Please hang in there. Do not let them beat you up. Do not let them discourage you from learning, right? You're the only one that can do this. You got to learn this. We can't do it for you. We can help you, but we can't do it for you, okay? You're going to have this knowledge up here. You're going to have to learn what your rights are. You're going to have to learn where they come from in law and how to effectively defend them as it is written, because the process is written. It's written right here. Article 1, Section 10 says you have the right to petition the legislature for the redress of grievances in Idaho. Do it to it, folks. I can't put that I'm putting that education out there, but I can't commit it to your brain. I can't make you speak it. That's something you're going to have to do. You have to be the law sayer. And in order to speak the law, you have to know it. And this is just the bare minimum. This stuff's supposed to be self-evident, the common sense law. So that's nothing that I can do. I can teach it to you. I can show you what it says. I can show you the law as it is written. I can teach it to you. But unless you pick it up and you put it to memory, or you go and get a constitution and carry it with you, you got these little pocket ones. Pocket constitutions, I've got 4 or 5 different ones. So you got to do that, folks. That's on you. I can't be there when you get accosted by these peace officers. I can't be there when the prosecutor is trying to prosecute you under a jurisdiction that's foreign to our form of government. You're going to need to know what your status is, what your standing is, and what your jurisdiction is that you give your consent to, and how to object to that effectively. Go back and start with episode 1. Work your way through. This is episode 6. We'll continue on with these specific subject matter episodes, kind of like in a chronological order, so you can watch them from the beginning on through, right all the way up to petition and remonstrance. You know, we talk about that all the time, but got to do the fundamental stuff first. So have a good night, all. Much love.